Hello everyone, my name is Clantis and welcome to the clan. So without further ado, let's get into this video. But before we get into the video, guys, thank you again. Always thank you so much for you guys smashing the like button and also subscribing to the channel. Welcome to everybody that is new on this channel. On this channel, guys, we are here with our two IQs. You bring your own two IQs to rub together and make sense of what's going on at the Gauteng High Court, because today it was a good day in the Gauteng High Court. I felt like, yes, this is how a court's supposed to be like when we, the public, are watching. And also have our self-appointed expert commentaries as we are here. We are no experts, we are no lawyers, we are no judges, we are not the court, we are not chambers, we are not attorneys' officers. We are just we with our brains, the two IQs that we bring on here, and then we make our comments and our opinions about everything that is transpiring at the Gauteng High Court. So speaking of the Gauteng High Court, let's go there in the Senzo Meyiwa murder trial. So, I was like, yes, this is what I like. I must be honest, guys, the judge impressed me today. Why did I say the judge? The judge impressed me today because he was interacting. Yes, it may have been in a way that was questionable. At the same time, I was like, but I liked the engagement between the judge and the defense, because all I could see on this judge's face, he was pinned against the wall and he could not protect his friend under any circumstances about whether or not to admit the Vivian Cronier's audio recording into evidence. And of course, Advocate Mngomezulu came, and I was like, Mngomezulu, come on, Mngomezulu. Okay, anyways, guys, you know, we like to be silly around here. But anyways, Advocate Mngomezulu, of course, he looked at Baloyi and said, we oppose everything that the state has submitted to this court, including the recording. But before it did, the defense did that, they first made a statement. This is now Advocate Mngomezulu, and I want to quote him word for word what he said. And I was like, yes, I'm impressed. Of course, I've got my papers here with me. So let me just read you how Advocate Mngomezulu opened his sentence to the court when he was opposing Advocate Baloyi's application. Of course, Baloyi's application is simple. He wants the recording to be admitted into evidence. So, which is something that was quite interesting that Advocate Mnisi did when he made his submissions to the court. He said, okay, we are in a trial within a trial. Meaning that the trial within a trial is to admit or dismiss the statement or the confession of accused number 2. Now that there is a new evidence that was brought by the witness that she recorded the the confession without informing the deponent, and therefore he proposes that there should be another trial within this trial. And of course, Judge Ratha was not having it. I understood Advocate Mnisi's argument, because Advocate Mnisi had something very nice in there. And I was like, yes, Advocate Mnisi, we want that particular witness that we want. Because he said, if the trial within a trial, we have a witness, for the recording, we also need to have a witness. And you and I you already heard from Vivian Cronier when she took the stand and said, in the room, when she was conducting the confession or the taking of statements, there was her, the interpreter, the deponent, his lawyer, as well as 2 officers that were standing outside. I'm not quite sure who else was in the room with all of those, especially Njiako. And the judge saw where Mnisi was going with this, and he was like, this is a trial within a trial. And this is like, listen what I'm trying to say. The trial within a trial it's about the confession that was made by accused number 2. And now that the witness for that particular process had made an, a statement that she made an audio recording. Therefore, we should also have another trial within a trial. And therefore, we need witnesses for that particular. And I was like, Nisa, you're smart. You are very smart. But of course, he was overruled by the judge who said, we are in a trial within a trial. And then in this trial within a trial, we are going to take it one step at a time. We're going to start with the audio recording. Ah, my goodness. You guys listen to Advocate Mngomezulu. I was like, you're good. You're good. I know I liked you. I know I liked you. And this is what he said in his opening statement. He said, I know... No, where are we? Why every time when I look for my quotes, I don't find them? This court is seized with an inquiry to make as to the admissibility of, firstly, of a statement that is alleged to have been made by accused number 2, which the defense is objecting to it and has raised the reasons for its objections. Remember, the reasons were that accused number 2 was forced to do this under duress. Secondly, he did not sign the statement. And thirdly, I can't remember. There were three reasons. Please remind me in the comment section, but let's continue. And he says, which the defense is objecting to it and has raised the reasons for its objections. Among other things, duress, which is coupled with non-compliance with freely and voluntarily. And it was not made in his sound and sober senses. This is when the judge interjected, which I found like, okay, Advocate Baloyi spoke without even you stopping him for a second. He said what he needed to say undisturbed, uninterrupted. And then Advocate Mngomezulu gets up and then he gets interrupted only in his first few paragraphs of his speech. And the judge now wants to know, why shouldn't he admit the recording? Okay, let me just quote him so I don't misquote him out of context. I think this is what the judge said. Can this court arrive at a decision concerning the inquiry which it is conducting without viewing? Objectively viewing the audio tape. Objectively viewing? Objectively? Okay. He continues to say, I know your submission is that this court shouldn't view it. Is that correct? And Advocate Mngomezulu said, yes, this court should not view the tape. And then he gave the grounds as to why. He started with the grounds of constitutionality of Magistrate Cronje sitting down with accused number 2 and taking down statement and confession without following the Constitution of the Republic of South Africa. One of which is that Section 14 of the Constitution, and I happen to have the Constitution of the Republic of South Africa, Act 108 of 1996. And Section 14 of the Constitution says, I did go and I checked it out. I was like, this also concerns me. I'm a citizen. Section 14 is privacy. Right there. Privacy. This is your constitutional right, by the way. And then it says, And then it says, everyone has the right to privacy, which includes the right not to have A, their person or home searched, B, their property searched, C, their possessions seized, or D, it is where we at right now, the privacy of their communications infringed. Remember, Advocate Baloyi said he is going to use RICA or Communications Act, whatnot, and that is why he wants this particular tape to be admitted into evidence, because he gave some case laws and then why this court should admit this tape into evidence. And then the Constitution of the Republic says in Section 14D, I'll repeat, it says the privacy of their communications infringed unless the deponent did give away their right and gave permission to Cronje that, okay, it's fine, I understand that you are recording this conversation or the confession, but she did not do that, meaning she violated section 14D of the Constitution. Not only did she violate section 14D of the Constitution, but she also violated section 35, subsection 5 of the Constitution. And so I was like, no, let's go there and check it out, guys. Let's go there as a clan and check it out. What section 35 of the Constitution says. Section 35 of the Constitution say the headings are arrested, detained, and accused persons. But Advocate Mngomezulu was focusing on section 35, subsection 5. And then I'm going to go to section 35, subsection 5 right there, which states that evidence obtained in a manner that violates any rights in the Bill of Rights, section 14 is in the Bill of Rights, must be excluded if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. You and I already heard from Cronje herself, who admitted that she did not inform the deponent that she was recording the conversation or the confession, which of course violates section 35, subsection 5 of the Constitution, read together with section 14D of the Constitution. So his right to privacy was violated by Cronje, as well as section 35(5) of the Constitution. This is when I saw the judge kind of like sorting himself out a little bit, and he tried to find a little loophole here and there by coming up with a case law of 1952 or something like that, and another case law of somewhere in the 1930s, and he was trying to get Mngomezulu to admit that he as a judge can take that precedent and persuade him into making a judgment in accepting these recordings. But of course, Advocate Mngomezulu said, I stand on what I've submitted in this court, and that is that the constitutionality of accused number 2 was violated by Cronje, was violated by the police or whoever else that arrested him and did not take him to court within 48 hours, did not charge him within 48 hours, the stuff that we already talked about in this very channel. And some people say, when you don't want justice for Senzo Meyiwa. What? What would I advise the Meyiwas to go and sue the state if I don't want justice for the Meyiwas? Secondly, why would the Meyiwas themselves say the 5 people stand accused of killing Senzo Meyiwa are not the people that killed Senzo Meyiwa? Are you also saying the Meyiwas don't want justice for Senzo Meyiwa? Whatever. But anyways, I was like, okay, cool. Of course, we are now dealing with just the constitutionality of this entire situation. That is the defense's standpoint. And they are saying they are not moving or shaken from this position they stand. Of course, if you look at the judge was like, okay, I agree. But of course, he was also pushed against the corner together with Advocate, Baloyi. And now another thing that I found very interesting was when the judge tried to throw off the defense by bringing in the whole talk of experts and asked Advocate Baloyi that, should an expert be called? And then, of course, Advocate Baloyi is not going to say, yeah, let's call the expert. Advocate Baloyi is going to say, no, let's not call the expert because the voice in the recording is that of accused number 2. But then I'm saying, no, if you are going to dismiss the defense and say, no, you're admitting the recording into evidence, then of course, let's have an expert. We need to know that, number 1, these recordings are authentic. Number 2, that indeed the voice in the recordings is that of accused number 2. And thirdly, we also need to see where editings were done or not done, etc. and so on. And I think I heard, correct me if I'm wrong in the comment section, did I hear that Cronje's laptop broke, stolen? What happened there? I did not hear that clearly. And how are they going to abstract this particular audio from her computer? And another thing that I wanted to know is, aren't the subs have like their own type of recording that is within the frames of the law? And then anything outside of the frames of the law, it is not admissible in court. Again, correct me if I'm wrong, do comment down below, because I am a little bit confused here when it comes to this audio recording, but I am very certain about the constitutionality of this particular evidence. And I've mentioned it yesterday in my video that no, accused number two's constitutional rights were violated. Almost all his rights were violated. Privacy, dignity, all of those were violated. And now having a fair trial. If this court admits these recordings, officially, the Judge Ratha will be presiding over an unfair trial. Of course, you guys know my stance about this trial. It is an unfair trial thus far because this judge is friends with the state. And then anyways, you guys know my opinion on that one. And I do not have to elaborate further because videos previously I've elaborated why I believe that Ratha as well as the state are in bed together, figuratively, of course. The other one sends the other one SMSs, and the other one sends the other one, calls and say, hey, let's caucus so that tomorrow when you go into court, we are in sync, that type of thing. And then it was also funny to hear Advocate Mngomezulu basically telling the court that Advocate Baloyi was quoting from the wrong piece of law, the FICA Act, instead of quoting from another piece of law. I giggled a little bit, and I did see the judge himself going like, yeah, actually he did, but he did not say it out loud because, of course, he'd be throwing his friend under the bus. It was hilarious. And, of course, Advocate Mngomezulu brought it as well, and I was like, yes, Advocate Mngomezulu. I was like, Mngomezulu, yes, Mngomezulu. Yeah, that was like, they were working together. And then she stood and concurred with Advocate Mngomezulu on the constitutionality of these recordings and why they should be dismissed by the court. So the court, of course, was adjourned until tomorrow to give the judge time to go and make his judgment. Tomorrow is judgment day on the recordings, not on the statement, on the recording. And this is my prediction. Okay, I heard a lot of people say, no, he's going to rule in favor of the state. No. Let me read you a passage in the Constitution. And so, which is going to give you an idea why Judge Mngomezulu needs to go home tonight and then write a dismissal of this recording on the basis of Section 2 of the Constitution. What does Section 2 of the Constitution? The heading is Supremacy of the Constitution. And it's just 2 sentences. It says, the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligation imposed by it must be fulfilled. Not may be fulfilled or could be fulfilled, must be fulfilled. And the reason why I'm reading the supremacy of the Constitution is because of Judge Ratha's case laws. He quoted Judge Krickler. I always had a problem. I'm so sorry, Justice, for always messing up your surname. Krickler. I think that's how you pronounce it. Judge Krickler, when he made some kind of a judgment, in fact, it was an opinion in his judgment regarding a case that they had done. And I am saying, according to Section 2 of the Constitution, where it says law or conduct inconsistent with the Constitution is invalid. So his opinion is invalid when it comes to the Constitution because accused number 2's fundamental constitutional rights were violated. Section 35(5) as well as Section 14(d) of the Constitution were violated by the person that was taking down his so-called confession. So, of course, Judge Mngomezulu, when he comes back tomorrow, he needs to have the Constitution, Section 2 of this Constitution in mind, that whatever he is trying to outmaneuver the defense with, that whatever it is inconsistent with the Constitution. And therefore, he should dismiss the tapes. That's it. The Constitution has spoken. It is the supreme law of the land. Not any kind of judgment that was done in 1952 or a judgment that was done in 1996 or a judgment that was done in 1930s. We live in a constitutional democracy. The draconian, colonial, and apartheid laws that he was quoting from, they need to go away, including this Robb versus Hapworth 1928 cannot play a role in 2023 constitutional democracy, post-1994, post-apartheid. Why is it taking us back there? There's no way we can accept this. And I am saying that tomorrow, this is my prediction, he is going to dismiss the tapes, and then they are not going to be admitted into evidence, and then they're going to focus on the statement or the confession, and I cannot see the judge admitting that statement into evidence because of the way it was obtained. It was obtained illegally. And then may I go back to section 35, guys, of the Constitution, which says, section 35, yeah, tonight, I did my homework. I did my homework thoroughly. I was like, there is no way we saw that, Baba. Section 35.5, which says evidence obtained in a manner that violates any rights in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. Case closed. And therefore, I'm not quite sure what's going to happen to accused number 1 and 2, considering that the constitutional rights were violated even by Mboto. Mboto violated accused number 1's constitutional rights too. And then came Ms. Cronje, who also did the same thing. So what happens thereafter? Are they acquitted? I heard some people say no, they will not be acquitted. They will be readmitted into the main trial and then continue. And in my mind, I'm thinking, Advocate Baloyi, at this point in time, your case is no longer just dead. It had a funeral and it's buried and it's starting to decay 6 feet under. Just close it and save taxpayers' monies and let's move on. And next, AKA's murder. Who killed AKA? That is the next thing that we want to know. And forget now that this is what is going on about Senzo Meyiwa's murder trial, because already this channel has said there are 6 people, possibly 7 people that were with Senzo Meyiwa on the 26th of October 2014. And one of them happened to pull the trigger that killed Senzo Meyiwa. And I say it again, accidentally. It was not intentionally, but at this point in time, it should be murder. So those are my thoughts about what had happened today in court. Guys, I may have left some other details in the video. I just wanted to focus on the constitutionality of the defense that it submitted to the court. And I was like, brilliant. Brilliant. This is exactly what we were talking about with the clan last night with the previous video. Exactly this, the constitutionality of accused number 2 as well as accused number 1. Period. We stand there. Guys, we are doing this and I'm so glad I have you in my life. I'm so glad that all of you come mature and sober in here, and then we are able to exchange these, these dialogues amongst each other. In my next video, I want to talk about my committee post regarding Magistrate Cronje. I may have come to a conclusion in my head, and that conclusion I think is highly likely, considering the people that may have gone to her and say, hey, listen, these are the people, this is what you need to do, and then this confession needs to be legitimized by you. But then she, outmaneuvered them and did what she did. We'll talk about that in my next video, because I feel like we may actually be unfair to Cronje. Maybe Cronje was playing an intellectual game on everything, that for us to read between the lines. I think I did while I was listening, and I was like, no. I think Cronje, wait, we'll talk about it. Let me not get over myself, ahead of myself. We'll talk about it. Anyways, guys, if you like the video, give it a like. If you didn't like the video, give it a like. Anyways, do subscribe to my YouTube channel. And don't forget to click the bell notification so that you get notified every time I upload a new video. Thank you so much to everybody that's super thanking the channel and supporting it financially. I highly appreciate you guys so very much. Leave me a comment down below and let me know, what did you think about today's proceedings? What did you think of the judge? What did you think about the engagement he was having with Mnisi? Because I felt this is what you call an intellectual conversation between learned people. I loved it. And then also share the video far and wide, and don't forget to like other YouTubers' videos and subscribe. Thank you so much for watching. See you next time with the next video, which is coming after this one. Goodbye.